We get into the big stories this morning. There is that call for the Attorney General Godfrey Adame to resign following some allegations from Richard Jakpa, a defendant in the Kasialato Force and Ambulance case, that the AG has been coercing him to implicate the minority leader. I'll be getting some details of that. Of course, now Nana B, popularly known of the MPP, has also hinted at the fact that he's mentioned a certain Supreme Court justice's name. Then there is the bit about the information being doctored in a way or some parts being edited. I mean, there are so many things that are being said, but some have also said, like Mr. Ansasari, who is a former director of the Ghana School of Law. He has said that, look, he knows the gentleman. He was one of the finest students at the time, that he cautioned him when he took up this position not to soil his hands, and that, well, maybe this would be a good time to resign. But what do my guests think on this beat? Joining me, we have Dr. John Osai-Kwapong. He's a CDD fellow. He joins me in the studio. I'll be introducing my other guests as well. Professor Appiah J. Etua is a lecturer, Department of Law. So the Faculty of Law, or the School of Law at the University of Ghana. There's Martin Kpebu, a legal practitioner. All of them join the conversation this morning. But let me come into the studio first. For you, you followed this issue. I find it interesting as a student of the law, ruminating on some of the back and forth and the plea bargains and, oh, I had a right to meet him secretly and no, it is not legal practice and you should resign. But bottom line, what is your reading of what this case has brought forth?
Yeah. So for me, it's a very serious allegation against an attorney general. Right? That if you look at what has been reported in the media, essentially I'm reading it as this is a case of quote unquote, witness tampering or trying to pervert the course of justice.
Witness tampering?
Yes.
Or trying to pervert the course of
justice. Right. And for me, it's a very serious allegation to level against none other than the Attorney General. And rightly so, the Attorney General has responded. The spokesperson for the office has also made an appearance on, a couple of media platforms.
You're talking about Isaac Wilberforce.
Yes.
Mensah.
For me, I think, though, that has sort of even raised further questions in the minds of, of people like me. But for me, it also comes at a very worrying time, which is how Ghanaians are currently perceiving our institutions of governance. And for me, that is the biggest worry for me. I mean, I don't know what would become of all of this, but the initial implications for me is we are at a time where, if you look at the most recent Afrobarometer, that trust in institutions and growing perceptions of corruption in institutions is at an all-time low. So you are hoping that we don't run into these kinds of news stories, events, issues that reinforce the growing mistrust in our institutions. And so for me, that is what I find very worrying.
Do you think this then puts a dent in that trust as far as, here's the thing. Some people have already felt, even moving away from the political terrain, have already felt that the justicial system is skewed. Yeah. Skewed against the poor man or the nobody and for the person with some wealth or a somebody, so to speak, in society. Then there's the political angle of, oh, Supreme Court this, you've heard the things that have been said, and now this also comes. Does it add another layer to that perception and the lack of trust in the justicial system, do you think?
Yes, it does. And in fact, for me, I feel like it puts a much greater dent and even worsens it. You have this current perception, again, going back to Afrobarometer. So you have this growing perception that there's a wide gap between how ordinary persons and what happens to them when they are found of having sort of broken the law versus, people in quote-unquote high places or what. I mean, that it's almost about a 50 percentage point gap now. And so when you read...
Which is wide.
Which is wide. And, you know, one of the things that democracies pride themselves in is the rule of law, right? That the law is no respecter of persons. Big person, small person. Once you are found to have broken the law will deal with you. So when you hear some of these things, that is what it does, right? I mean, the Chief Justice recognizes some of the challenges facing our current judicial system. I think it was about a month ago where she announced this leading justice reforms to address some of the challenges with our judicial system, which I think is a very good move. But again, hopefully it addresses what we are currently seeing as how people are not just perceiving or feeling about our justice system. Trust is at its lowest, you know. So when, again, these things emerge and you look at the conversations surrounding it, it deepens that, yeah, maybe I shouldn't have that kind of confidence in this institution, which is worrying, because if you can't trust your justice system, then where do you go to resolve grievances? Where do you go to settle disputes? How do you make sure that people get, you know, a fair trial, the due process is... I mean, the implications are, you know, you're talking about a ripple effect on a whole lot of things.
I mean, you're getting me thinking about the Hobbesian, you know, chaotic state of nature, so to speak, which some would say that never existed.
Right.
But where, if I remember my political science and maybe philosophy, where life is poor, nasty, brutish, and short.
Exactly.
Poor, nasty, brutish, and short. Because then, if people have nothing to lose and they feel the laws do not aid them,
exactly,
they would want to go outside of the law. And that is what you want to prevent in a society like ours.
Exactly. That is what you want to prevent. You want to make sure that people walk into the hallways and corridors of our courts with a lot of confidence. Even if they lose a case, they know that due process was followed. They know that they were treated
I lost justly.
Precisely. A lawyer reminded me on social media that of this saying that justice must be seen to have been done, right? It's not that justice happened, but it also must be seen to have been done. So it's a worrying time. And for me, it's not that there's ever a good time for a bad story, but this is a bad time for a bad story.
Yeah. Now, looking at all these dynamics that you've made mention of, that lends some cold comfort, right? But the other side of it is that recently, for example, my colleague Samson Ladi Anyenene had a conversation with the Chief Justice. You've already spoken about the LEAD initiative and all of that. Some would also tell you that things are not as bad as we see it, and that justices of our, especially the superior courts, you know, the high courts, the Court of Appeal, the Supreme Court, our apex court, by and large, do exceedingly well in going through the matters that mechanisms have been put in place, for example, ensuring that courts are in many more areas to hear cases and all of that. What I do not know, or what maybe has not happened, you know, still the paucity of lawyers, okay, legal representation across the country. It is woeful. That one will not even get into. Most people have to come to Accra because most of these legal practitioners also want to be in Accra and Kumasi, by and large. But there's also something to celebrate. Some would say that we've not hit such a low that we should be lampooning the judiciary in this manner. Would you agree with them?
I mean, I agree that good things are happening. I'm sure on a daily basis our justice system is doing all it can to deliver justice as best as it can, right? All the things that our courts are involved with, that on a daily basis they are making sure that those things happen. But it also goes without saying that everything is also pointing to low trust, growing perceptions of corruption, right? Which means that there is also something about, in the midst of all the work that is being done, there's still something about the institution that citizens are feeling somewhat iffy about.
Yeah.
And so for me, even as we acknowledge the good that is going on, we cannot afford the luxury of ignoring the warning signals. And as I said, how come that citizens are having this low levels of trust, growing perceptions of corruption, feeling as though the law treats persons in higher places better than ordinary citizens? There has to be something that they are experiencing, or there has to be some actions or inactions of the judiciary that is giving citizens this feeling. The other dimension too is that, and I keep asking myself, I wonder why when it comes to our institutions, partisans tend to trust our institutions slightly better when their preferred political parties in power.
Exactly. And a typical example would be the Electoral Commission.
Right. So exactly. So that even adds another dimension to the challenges facing an institution like the judiciary.
Let me bring in Professor Appiah-Etua. He's with the School of Law at the university, or the Law School at the University of Ghana. Prof, good morning.
Good morning.
It's really good to have you join the conversation. I will take your initial thoughts on this entire development from the standpoint of the ordinary man and from the standpoint of a practitioner, a lecturer of the law. What is your reading of what we have seen and heard so far?
Thank you for having me. I think the issue, when we talk about plea bargaining, it's about an agreement that is entered into between the prosecutor and the defendant in a case, or the accused person, for an agreement to be reached so that the full hog of the legal process will not take place. And the defendant will admit to some wrongs, and there will be a reduction in the charge or in the sentencing or the costs related to the matter in dispute. And so at the end of the day, it comes about through some form of negotiation between the parties, that is the defendant and the prosecutor, where the prosecutor, the defendant has a lawyer. The lawyer will be involved in these arrangements. When the agreement is reached, the deal is struck, then the matter will be reported to the courts, and the court will take that into account in the sentencing or conviction of the accused person. Another reason this comes about, plea bargaining, is brought into the discussion or the process, is the fact that one of the parties, there may be more than one defendant, and there's a key defendant in the case or the accused person that maybe the prosecution wants to center its case around. And so the other parties who are, if you like, the small fishes, may want to volunteer some information which is not directly available to the prosecution, but which may be necessary or relevant to find the defendant or the key accused person or defendant culpable, to give that evidence or to support the prosecution to ensure that some weaknesses in that person's testimony is released to enable that person to be found culpable, and that will make a bigger case for the prosecution than including the smaller fishes in the whole deal. So these are some of the scenarios and situations that come about with regard to plea bargaining.
Right.
Now, linking it to...
Do go ahead. You were making a point.
Linking it to the case we have in hand, it is a little bit complex. In the first place, we don't have all the facts. So some of the facts that we have are one-sided, coming from one side of the prosecution or the defendants. And so it's a little bit difficult to come to a clear conclusion as to the direction the case might go. So it's a matter of saying that if this is what is said, and if that is true, then this is likely to be the conclusion that may come about. And so based on that, among others, the third accused person is saying that the Attorney General sort of cornered him and tried to push him to give evidence that would nail the first accused person, who is the minority leader in Parliament. And if what the third accused is saying is true, then there is some rules relating to the plea bargaining which have been violated, which is that it should be done of the free will of the parties, through the free will of the parties. There shouldn't be any imposition or any way to coerce somebody to give testimony against somebody or to concoct some evidence against somebody. And so that is where I find problematic about the whole saga that we have before us.
Right, and some clarity there. So, I mean, you've already started talking about plea bargaining. For example, the Daily Guide today claims that their sources also confirm, some speakers on the MPP side have said that, oh, we have a video, in fact, of the minority leader attempting to enter some sort of plea negotiation or arrangement with the Attorney General. So let's clarify. What are the do's and don'ts in plea bargaining? Can we situate the context from there?
The do's and don'ts of plea bargaining. One of the do's is that it is something that the laws of Ghana allow. It was limited previously, but there's now an act specifically dealing with plea bargaining. So it is not something wrong to do. Now, it is also allowed for each of the parties in a plea bargaining, in a criminal case, to offer for the plea bargaining, either from the prosecution or the defendants. Another do is that it should take place in an environment which is not induced or coerced. And it should also take place if the accused person in this case has a lawyer. The lawyer should be involved. The lawyer should could initiate the process, and he could decide to speak on the part of his clients.
So then my question, can a client without representation have an interaction with, for example, the AG, the Chief Prosecutor of State, in any setting when it comes to plea bargaining? Now, Isaac Wilberforce-Mensah, who speaks for the AG's department, has said that Richard Jakpa had changed lawyers a number of times, about 3 or 4 times. And so at the time, there was some interaction with him. It had to be without legal representation, though the claim has also been made and verified from our end that this happened at the residence of and at the request of a certain Supreme Court justice. I don't want to go ahead and mention those details, but would that then make it right if any such overtures were made, and if indeed there was an ask to implicate the minority leader? Would that then be justified?
Well, as it stands now, we don't know the full facts regarding when or whether the third accused had a lawyer at the time he was approached by the AG, or whether actually he approached the AG. I don't know which way it is, or what is the facts that really support that. But the point is that, as I said, each side can initiate the process. What is a little bit concerning for me is the fact that it was initiated by a Supreme Court judge. I think that he's part of the judiciary, and therefore he should have stayed off in this process. Especially
when you say stayed off, you're talking of the Supreme Court judge in question or the AG?
The Supreme Court judge in question.
Okay.
Yes, especially if the facts which are coming out is true, that the AG tried to coerce and to force the third accused to give testimony that would be sort of concocted, and it's meant to ensure that the first accused is convicted and sentenced. It's because in that situation, it could be construed and implied that the Supreme Court judge who offered his space for that interaction to take place is condoning something which is wrong.
Right.
And so, but I guess all these are, if you like, speculative at this point because we don't know the truth. But if what we are saying is true, then the Supreme Court judge would be in violation of the ethics of his profession.
Hold for me, Prof. Let me also bring in a lawyer, Martin Kpebu. Mr. Kpebu, good morning.
Yes, morning, Mr. Kapo.
I hope you're well.
I'm very well. Very well.
I've heard you speak copiously on this matter, and you've made a few points. But as of now, with some of the latest information we have, it's pointing in the direction of a certain Supreme Court justice for reasons I'm sure you understand. I don't want to go ahead and mention the name of this justice of the Apex Court. But then there are also the fineries of dissecting what plea bargaining should be or what it ought to be versus what it ought not to be. What is your reading of the matter so far? And I've painted some pictures, some dynamics in respect of whether or not Richard Jakpa was accompanied by his lawyer and what that would have implied on either end. And this whole conversation purportedly in the residence of a Supreme Court justice, and it's being recorded. I mean, it's a whole envelope of matters. Let's unpack it from your end.
Okay, yeah. So let's start with the Richard Jakpa angle, what we are seeing so far. No, the thing is that to the extent, yes, the law allows for plea bargaining. Nobody doubts that, right? Yes, but the law also circumscribes, gives conditions, etc., for how plea bargaining should be done. Now, the first issue we are looking at is that at the time the Attorney General communicated with Richard Jakpa, why wasn't the lawyer present? We've subsequently heard
we've been told, Mr. Kpebu, that he had been changing representation, and this was one of those windows. The spokesperson for the AG's department had mentioned that on about 3 or 4 occasions, he had changed lawyers. Have we lost Mr. Kpebu? I think we have. We'll try to get him back to answer that. I just had to clarify that because I couldn't let him go on that point without making the clarity. But coming back into the studio, this makes for quite some curious, I mean, when you look at the names that are being bandied about, especially in the case of a Supreme Court judge being involved, and why we're only hearing now that there was such a recording, as has been situated, plea bargaining is allowed. But how it is done is where the devil is. But let me just, we have Martin Kpebu back. Let me pick his thoughts again, and I'll come back to you. Martin, we lost you briefly. Please continue with your thoughts.
Yes. So the first major question is, at the time the Attorney General communicated with...
Hello, Mr. Kpebu. Mr. Kpebu, can you hear me, please? All right, so it appears we have a bit of a challenge with Mr. Kpebu's connection. We'll try to work on that. The technical team is on it so that we can have a fluid conversation. But I was saying, again, that looking at all of these dynamics and what ought to be and what ought not to be, that's where the devil really is. And even as a student of law, I am looking at it and I am wondering, something is not adding up. Something, let me just leave it there. Something is not adding up. But why did those things happen? For you, I don't know whether the thinking process is the same for you.
Yes, and you know, there's this thing that I coined after reading a piece that Professor Kwesi Prempeh wrote way back in 2005. And I think I've mentioned it on your show before that I call it the legal test versus the appearance test.
Right.
And whenever there is a situation involving public institutions, public officials, I feel like the approach is, okay, like you said, the law permits plea bargaining, there are do's and quote unquote, there are don'ts, right? But we tend to look at things a lot strictly through the legal test. Okay, so did I, quote unquote, break any rules? Did I break any law? And if reasonably it can be determined that, well, there's nothing necessarily wrong with what I did as per the law, then maybe it is okay. But what matters for me and where our public institutions lose confidence and where our public officials tend to get into trouble is what I call the appearance test. Right. The way things look.
The optics.
The optics. And I think sometimes we are a little too oblivious or nonchalant in paying attention to the appearance test and the extent to which we are passing or not passing that appearance test, right? Because when you look at some of these, at least what we know so far, for me as a lay person, as an ordinary person, you look at it and you say to yourself, something just doesn't look right. Something just doesn't feel right. Maybe nothing untoward happened, but on the face of it, it is some of those iffy feelings you start getting that then starts translating into how you start feeling about public institutions and about public officials. And I think if our institutions and those who man them or those who are custodians of it would start paying attention to how certain actions and inactions, when eventually they come out, look and feel to citizens, I think we'll be a little more sensitive and a little more careful in the kinds of things that we engage in, even if we believe that doing those things may not, on the surface of it, break the law.
Right, and that's a tricky bit to navigate. Let me just acknowledge as well, Ankuma Kwesi Teria, you say, Ben, I'm watching live from Chiba City near Tokyo, Japan. So we're representing in Japan today. Thanks for watching. Mr. Kpebu, my apologies. The connection has not been that good this morning, but I'll allow you to make your thoughts. Let's try one more time.
Okay. Yeah, so I mentioned that the first point is that why would the Attorney General engage JAPA directly? We are hearing that at that time, JAPA did not have a lawyer. It doesn't wash because so far the Attorney General hasn't brought any evidence out to show that JAPA did not have a lawyer.
But on the face of it, would it be wrong for the Attorney General to engage Richard Jakpa in the absence of a lawyer, for him to engage him alone? Would it have been wrong?
Yes, absolutely. Because the plea bargaining law, you see that section 162 in section A to R, one of them makes it clear that when the accused is represented by a lawyer, then the Attorney General should deal, the prosecution should deal with that lawyer. And the reason is obvious. Generally, the client, the accused, doesn't have as much knowledge. That's why he is late. That person is late. Even when the person is a lawyer, look, when they put you on the stand, when you are in a criminal trial, the way you would think is different. That's why if you have a lawyer, the court says, hey, deal with the lawyer. So the Attorney General breached the law for me right now, looking at it to the extent that he hasn't brought out any evidence to show that JAPA was not represented.
But shouldn't you be waiting, patiently before you issue a verdict on the matter? You're stating categorically that you feel the AG erred. But let me ask you, would it have made any difference if it were the AG, Richard Jakpa, without representation, and a Supreme Court justice? Would it have made any difference with the addition of that justice?
Yes. Now, with the addition of the justice, it opens another angle, another problem. You heard something talking about the ethics of the judge. The judge has no business trying to solve that problem. No. He's not allowed to. A pending criminal case, no, he's not been appointed as a mediator, so to speak, to help in the investigations. No. Rather, it's contrary to his ethics. It's contrary to his ethics. It cannot be allowed. So that even makes it worse, that you have two professionals, 2 lawyers, against one, lay person, right? Yeah, so it's very dangerous. It doesn't matter that, it may appear that the judge was trying to help the accused. No, once he wears the cap of a judge, formally he's a judge, no, it makes the situation worse. Because he's not supposed to dabble in such pending cases, not with what they were concerned with, trying to do a plea bargaining at that odd venue.
Now, speaking of which, I have read from some instances, for example, the former director of the Ghana School of Law, in terms of some processes that should have been followed and where this could have been done. Legally speaking, just clarify for me 2 points. In such plea bargain arrangements, is the location an issue in point? Is it important where this happens? Some have said it should have happened in the chambers, at the Attorney General's and other specific places, not within the parameters of the House of a Justice of the Apex Court. That is point 1. And then point number 2, the Daily Guide is claiming that it has gathered that there had been incessant pressure piled on the AG by Atuforsen to discontinue the case. My second question is, could this be true? Can the AG be pressured to do anything in this kind of setting? 2 questions for you.
Okay, good. So the first one, yes, when we point to we look at the plea bargaining law, the section 162, which is the amendment to the Criminal Offences Act. So this plea bargaining law is Act 1079. You don't find an express provision, right, saying that it cannot be in the house of a judge. But you heard what Dr. Kwapon also said, the appearance test. It makes it very odd, very, very tacky. Besides, you had Mr. Ansas, former director of the Ghana School of Law, how he narrated how Justice Emisa lost his position as Attorney General because of the similar meet in the House, that, right? So it tells you that in our jurisdiction here, even in the absence of an express act of Parliament, we have put our own soft law, which we implement, that look, don't do plea bargaining in the house of a sitting Supreme Court judge. That is our soft law, and from the 70s. So if we cannot implement it today, then it means that we are losing our way. Because if in the 70s, that was long ago, over 40 years ago, we could mark such a conduct as illegal, not acceptable, it's against our morals and ethics in Ghana, then the beggars believe that 40-something years on, we cannot implement that same rule when we are supposed to be making progress. That's tightening the ethics rules. So that's it for me. So I strongly believe that to the extent that the negotiations went on there in the House of the Supreme Court judge, like the Emisa rule, it means that the Attorney General should go.
Right. Yeah, on the second point, of whether the AG can be pressured, what's your reaction?
Yes, look, Mr. Kapo, let's speak bluntly about that particular one.
Right.
It happens all the time. Oh, you find M3, even we go, AG, this one, don't prosecute it. There's no evidence, this. So that one is normal business, so to speak, because the thing you call pressure is also a form of plea bargaining, because you're trying to draw the Attorney General's eyes or his attention to deficiencies in his case. So the thing we call the pressure, lots of it is actually informal plea bargaining, because usually we approach the Attorney General to show that, look, this place, you don't have evidence here, you don't have this here. It's this is political witch hunt. This. So it's normal. So I wouldn't be surprised if Atuforsen went to him. It's normal. But it's a different kettle of fish when an accused is saying that the Attorney General tried to suborn him to perjure to perjure, give false testimony to the court. That is the one that is obviously a crime. So you see,
okay, so you've answered that. You've answered that, and you say it's a crime. But the real question was, can the AG be pressured in the sense of, yes, some will try to apply pressure, but can the AG be pressured to act in any specific way? That's what I want to, as Attorney General. Is that a possibility?
Oh, it's the stock in trade of all the government. Usually you put pressure on the Attorney General.
Right.
Oh, it's stock in trade.
Okay.
So this one, you can see that the party higher up want Atuforsen convicted because Atuforsen is a thorn in their flesh.
Right.
You see, he's minority leader. So if they can get him convicted, that would be a more or less a fatal blow to the NDC. That your minority leader is in jail for what? Causing financial loss, etc. You are not fit. NDC is not fit to come back.
Right.
So that one is very clear. Why, Mr. Kapo, why do you think he's refusing to accept the money from Big C? When Big C wants to return this money to us, the money for the ambulance, which money we badly need, yet you see Dami saying, no, they are not interested in the money. It's because of the political witch hunt, because of that political vendetta.
Well, you're stating categorically you think it's a political witch hunt.
Absolutely.
Okay,
without batting an eyelid.
Right. Mr. Kwebu, hold for me.
Eyelid.
Right. So, Prof, Mr. Kwebu thinks it's a political witch hunt. But you have to look at the other side, because while he suggests that it could be this because, look, I mean, the minority leader is a thorn in the flesh of the NPP, you can also look at it from the other side. Some have said that even while the current Attorney General, Godfrey Adami, was a deputy, he was a thorn in the flesh of the NDC. In fact, most of those court cases, he was on them. And that since that time, they have been trying to target him, bring him down, that his vetting was one of the longest when he was being made a substantive minister. So to say that there is cause, justifiable cause for the NDC to be going down this road, which is what brings me to my next question, Prof. Why now? This Cassiel Atuforsen, Dr. Atuforsen incident has been with us for a number of years. Why now? Do you agree with Kwebu that it's a political witch hunt? I want us to look at the political versus the justicial optics. Why now? Your response will be what?
Well, I beg to differ somehow from Mr. Kwebu with regard to the pressure that is being mounted or could be mounted on the Attorney General. I think that we have to look at things from the fact that we don't have all the facts, and so we should avoid a little bit of conjecture. And it's also clear that if the first accused actually went to see the Attorney General to sort of try to kill the case, I think that is also wrong. It will be an attempt to influence the outcome of the case. So in that respect, I think that if that is proven that happens, then the first accused person may also have a case to answer. Now, the political hunt, which, as I'm saying, is a little bit of a conjecture. I think, for me, I would just look at it as coming from a lawyer, and my take on this is that let's look at the facts. If it seems to be clear on the face of it that what the Attorney General did is wrong, subject to the information or the facts we have been conferred. And as to whether it's a political witch hunt, I'll not be able to respond directly to that. Now, so having said that, the point I want to make is that because some of the information that we have has not been responded to by the other side, we need to be a little bit careful how we make conclusions. Having said that, I want to be clear and say that if these facts that are coming out are true, then the Attorney General shouldn't wait to be told what to do, or there shouldn't be, some are calling for a probe and so on. The Attorney General should do the humble thing and just resign, actually, so that it will serve as a means of supporting the integrity of the judicial process as a whole. Because
but what if the Attorney General does not feel he has erred in the matter, and we've known his posturing over time. You are saying, regardless of it, to save the face of the institution, he should resign?
Definitely, definitely. So I support the call coming from Mr. Ansansari, that he has to do the honorable thing and just resign. And that will save the image of the Attorney General's office, which is a very high office. If you look at Code 88, it is solely responsible for prosecution of cases. And so if the office is tainted in any way, it affects the kind of cases that they bring about and to prosecute. So he should do the honorable thing and resign. If the facts coming out, he knows it, that it is true or not. Because my other concern is that he knows the law. He is the one responsible for drafting the law, and when it came to place, he organized training sessions and so on for the judiciary, some lawyers and so on. So he knows the law. So there can't be a situation where he can excuse himself that, oh, I'm sorry I erred, or I'm sorry I did this in which was against the law. So for that matter, he should do the honorable thing and resign. And that is what I would say. If he doesn't, then the responsibility now shifts to the president to do the honorable thing and sack him.
Do you honestly expect that could happen? I mean, first off, do you expect that Godfred Yeboah-Dame would resign? And do you expect that if he doesn't, the president would go ahead and replace him?
Well, from the records, it doesn't seem so. But I think that to bring credibility to the office, that's what he has to do. And if he doesn't do that, the president should also go ahead and protect the credibility and integrity of the office of the Attorney General. And if that doesn't also work, again, the record seems to show that it may not. But you never know. But if it doesn't, there are other options and avenues available. A parliamentary probe is possible. That could also be undertaken. Special commissions of inquiry can also be set up to do that. And I think that we shouldn't let this matter rest, because it goes high up there to the level of the Attorney General's office. And so something needs to be done. This is not a prosecution by a case involving a prosecution from a police station or a lower level, but high up there. So if we really want our legal system to be respected, the criminal justice system to have that kind of credibility, then something needs to be done. Either the AG resigns, or he's sacked by the president, or a commission of inquiry is set up, or some probe undertaken to ensure that the whole issue is unraveled and we get to the bottom of it. So at the end of the day, justice is served. Because the issue also around the $2 billion or euros that was offered to
2 million euros.
It's also concerning, because the whole debt saga involved in this matter, the cost is about a little more than 2 billion euros. So if that is the essence of plea bargaining. If somebody who is even a non-accused person, but is connected somehow to the case, says, I want to settle this amount. Again, if that is proven to be true, if that is the case, then certainly the Attorney General faulted or didn't do his work well, because at the end of the day, it's about being able to retrieve the cost. That is a new element involved in criminal justice, not just about punishing and sentencing, but it's also about retrieving costs and lowering costs. That is even the essence of the plea bargaining. You don't want to go to the full process, because you can cut costs by entering into some deals which are allowed under the law. And so that is my take on this.
Prof, hold for me. I'll come to you for one final bite. But that is the curiosity, because this message that comes through from Daniel Gnari, I hope I've not butchered your name. You're watching from France. You say, and I'll cut to the chase, why didn't he, that is the Attorney General, accept the 2 million euros that were proposed to him by the company that supplied the ambulances? He refused to accept it, and you say simply because he wanted to do anything possible to jail certain people. And Dr. Kwapong, when you talk of the optics, these are some of the things. Prof is saying that we shouldn't let this matter rest. The AG should resign honorably, and if not, the president should relieve him of his duties. What happens if neither of these two people act in the way we expect. And the president himself is a lawyer. And I'll just add to this. Ansah Sari says, and he is former head director of the Ghana School of Law. He says, Mr. Dame is experienced and well aware of the law. Therefore, meeting with an accused person to enter into a plea bargain in the manner that it has been reported, and if that proves true, raises questions. And he says, quote, my candid opinion is that the learned Attorney General knows or is deemed to know the law. Apart from the judges, I think the other person we can see the law rests in his bosom is the Attorney General. So where do we go from here? Are you also in support of a resignation?
Not at this point.
Not at this point.
Right. But I still think that if there are any additional facts to be unearthed, I still think that this is something that must really be looked into, because the consequences are quite damning. I mean, to think of the fact that this can potentially even taint the case.
Exactly.
You know, especially if these accused persons are convicted, right? Would it leave that hanging clouds and doubts as to...
Would it be viewed as justice having been served, indeed?
Precisely, right? So it's a matter that must be fully probed, must be fully looked into. All the facts, you know, are unveiled. We just can't turn a blind eye and let this die. Now, as to what the ultimate consequences becomes for the Attorney General, I think for me, I want a little bit of time and events to see what would, you know, come out. At this point, for me, I just want to give the AG a little bit of a benefit of the doubt and trust his better angels, right? That he was not or intended to be involved in anything untoward. At this point, I want to grant him that. But I think with more, as the story unveils, should it come to the point where it is really shown that, look, this just again doesn't look right, and that some infractions were really, you know, done or occurred along the way, then I think there has to be that ultimate consequence of, for the sake of the institution, for the sake of the office, and for the sake of public confidence and trust, it would be the right thing.
So give me a straightforward answer on this. Do you feel by all of what is happening, the office has been tainted? Not necessarily the person, but the office?
Yes.
You feel it has?
Yes.
All right. Mr. Kwebu, you have the final word in about a minute. What will be your final words? I know for you want him to resign, right?
Absolutely. He's wasting time. Listen, Mr. Akaku, if the AG had a better case than what he put out now, he would have brought it.
But don't you want to be well versed with all the facts, like Dr. Wapon is saying? Like, I mean, there has been talk about some videos and audio files. Don't you want to see everything before you come to a conclusion?
No, we've already seen enough for him to go. One, the emitter rule, so the venue in the house of a sitting Supreme Court judge, that alone is enough for him to go. Justice emitter had to go as Attorney General. You heard the director of the law school. So that's done. That's done. The emitter rule alone is sufficient. Two, he has embarrassed the Supreme Court judge, and the Supreme Court judge who has something to answer for meddling in this case. So for going, as soon as he went in there, he said he went to see the Supreme Court judge. So when Japa came in and they sought to continue the conversation, he was supposed to pull out.
Right.
So once he didn't, please, the rules have been breached, the ethics rules. So the judge himself to have a case to answer. So based on this, you see, the more we continue the discussion, it's going to drag the Supreme Court down. The Supreme Court already is not too popular in Ghana, okay, in the recent past because of certain decisions. So this particular case, the more we continue, drag the court down. So Dami has to keep quickly so that he can then stop these discussions.
Right.
By Saturday, people will throw it against the court to be possible forced to recover.
All right.
That's
Mr. Pebu,
he just resign quickly before it gets. You resign quickly because the discussion is going to go on and on and on. You see the end?
All right. Mr. Pebu, I think we've got the thrust of your argument. You say the discussion will go on and on and on, and he should resign quickly. Only time will tell whether that will happen. Prof, I did say I would come back to you. I'm giving you 30 seconds, final thoughts before we draw the curtains. 30 seconds, Prof. Any final thoughts for us?
I think the plea bargaining idea is a good one, and we need to uphold it. And to be able to do so, we need to ensure that something is done about the way the whole process with regard to this particular case has been scandalized. So I'm hoping that the facts will come out, and at the end of the day, we'll ensure that justice is served for the defendants, and then the name or the integrity of the office of the Attorney General also be protected. And that will mean resignation if he knows the facts, and so he should act on that if that is true, or a sacking or a probe being instituted. Thank you.
It's pretty clear, but you said something I missed. You said something had been scandalized. What has been scandalized?
The plea bargaining process.
Okay. All right.
Yes.
Thank you so much, Prof. So those who joined us for this conversation, Professor Pierre J. Etua, my former lecturer in public international law. He's lecturer Department of Law, or better still, the law school at the University of Ghana. Thank you for joining. We also had Martin Pebu, a lawyer, and in the studio, CDD fellow, Dr. John Osai Kwapon. We're grateful that you made the time. And yet, time behind the Uber studio, so we are grateful. We're grateful you passed through today. Well, stay with us, because up next, we're going to be talking about a crucial issue for those who ply the Dawinya-Tema stretch. Residents, motorists alike, the stretch is one filled with frustration. It's a never-ending gridlock, day and sometimes in the evening, leading into the night. We are there today to bring you more, to explore the ways forward as we engage the Ghana Highway Authority. That conversation comes to you next on the AM show. We'll be right back.